At first, it sounds like a routine courtroom hearing. Motions filed. Lawyers present. But within moments, the judge makes something very clear: the defendant cannot play lawyer and client at the same time. And as the hearing unfolds, the details get darker: a murder charge, video evidence, prior violent felonies, and a bond set at $1 million. What happens next explains why the court refuses to budge, not even an inch.
Yeah. Yeah, if there's any, there's not.
He's fine. He's fine. He filed.
They don't go in, they don't.
I'm not.
All right. In 24 CR 2449, viewer JW Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. He's filed a bunch of motions on your behalf, and okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not things I'm going to consider, because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. He's been assigned. I don't know. Did you hire him?
No, I was.
Okay, you were appointed, and okay, you want to represent yourself. Anytime you want to do that, let me know, and that would be a bad choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See you. He's a wise man and he's a good lawyer. You got to trust. Run it by him. He knows how to do it and what is the best way to represent a defendant. Okay. Yes. All right.
Your Honor, if I may, one of the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the
yes, sir.
briefly, is that prior to the charge of murder being filed against him, he was out on bond. There are other cases in this file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond, murder charge, and he's been in custody since then. He's asking for consideration, possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million, and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. And at least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, another the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times. Both of the individuals doing that.
Anything you want to answer? You need to go? Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime, unless it's multiple murder. Number two, you, according to this indictment, have at least 4 prior felony convictions dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is, number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, it won't take much. I think the co-defendant is currently set for October. So
anything can happen in a case.
I think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We got everything ready. Mr. Marshall was arrested after this, after we received some additional information.
Lacey, I need to set right after the co-defendant's case.
Yes, sir.
Okay, we'll get it. Please
Yeah,
note it.
I'll file real quick and then I'll get them a date.
Anything else on this?
No, Your Honor,
Nope.
we'll be
Thank
excused
you.
of that.
That is all. Yes.
We can look at it again if we're not ready.
Yes, sir.
At first, it sounds like a routine courtroom hearing. Motions filed. Lawyers present. But within moments, the judge makes something very clear: the defendant cannot play lawyer and client at the same time. And as the hearing unfolds, the details get darker: a murder charge, video evidence, prior violent felonies, and a bond set at $1 million. What happens next explains why the court refuses to budge, not even an inch.